Assalamualaikum and hi. Today we will continue with the topic 4, right and responsibilities of employers, employees and their trade unions and the powers of the Director General of Industrial Relations as stipulated in the Industrial Relations Act 1967. Basically, this topic will be divided into three main sections. The first one is about rights of employees and employers, while the second one is about the responsibilities of employees and employers, and the third one is the powers of Director General of Industrial Relations, and this is actually based from the Industrial Relations Act 1967. Introduction. This topic will basically explain about what are the responsibilities for the employers and employees when we talk about industrial relations. Simply put, the responsibilities can be said as the duties that must be fulfilled by not only the employer but also for their employees, and at the same time the trade union if the employees or in that organization establish their own trade union. So basically these three parties, employers, employees and trade union, have their own responsibilities. And in the same time, both parties, which means the employees and employees, must strictly adhere to the stipulated rules and regulations as mentioned in the Industrial Relations Act 1967. As you can see, or if you can recall, the previous chapters we have also talked about the various what we call concept and major things when we talk about the powers, duties of the what we call director generals, but that one is actually the director generals of the trade union. But for this topic we will focus on the powers and the duties of the director general of the industrial relations. The responsibilities of those parties can also be categorized into general and specific responsibilities, which to be explained in the next slide. Now we move to this slide, rights of employees and employers in organization. You have to remember, when you work in any organization, you can exercise this right. So the first one is the right to form trade union. If you join any organization and let's say that organization is yet to have their own trade union, then you can establish or to form the trade union in that organization. Number one. Number two, if you join the organization and that organization already established, already have their own trade union, so you have the right to join the trade union, to become a member of the trade union. And the third one, if you join the organization and you join the trade union which already established exists in that organization, then you can also have the right to take part in its lawful activities. For the lawful activities, for example, like if the trade union organized strike, picket, involved in the process of the collective bargaining and etc. But you have to remember, this must be a lawful activity which is permissible by law, and this law is actually, you can refer to Industrial Relations Act or the Trade Union Act. Okay, so in the same time, okay, if you exercise these rights, for example, you have to understand one thing, that nobody in the organization, regardless of whether you are the employer or employee, should not interfere, should not restrain, and should not cause an employee or employer to do these things, to form the trade union, to join the trade union, and to take part in the lawful activities. Responsibilities of employees and employer. General responsibilities of employees, employee and the trade union. This one we can refer to the Industrial Relations Act 1967, Section 4, Subsection 2 and Subsection 3, which clearly explain about the responsibilities of the employers, employees and the trade union. Section 4, Subsection 1 stated that prohibition against any interference, meaning to say that we are prohibited against any interference or any restraint or coercion in respect and exercise of the rights which I have explained in the previous slide, given to the employees and employees by any person. This slide actually re-emphasizes on whatever I have explained before in the previous slide, which stated that the prohibition against any interference, meaning to say that nobody can interfere the process of the establishment or the administration or the functioning of the trade union, meaning to say if there any effort or initiative in that organization to establish the trade union, or if they already established, how the trade union is administered by the members, or to functioning the trade union, meaning to say to come up with the programs, to organize program, event, exercise their function and duties of the trade union. Nobody can actually interfere that process. Number 2, okay, section 4 subsection 3 stated that prohibition against the giving of any support, meaning to say that if the idea or the initiative of establishing or forming the trade union, so nobody is actually can actually against to give any support. Okay, this is actually to address on the employees union by an employer or an employees union, whereby the objective of giving that support is to place the employees union under their control, meaning to say that the management, the employer cannot actually control this process. Now we focus and emphasize on the employers. Okay, so under the Employer Prohibited Acts, okay, section 5 subsection 1 Industrial Relations Act stated that employers are prohibited from the following, meaning to say that employees are not allowed to do this. So we have something about, if I'm speaking about 5, yeah, intimidating behavior, which is actually prohibited according to the law. The first one, okay, imposing a condition in a contract of employment which restrain the rights of a person to join or continue to be a member of trade union. For example, if you join any organization, yeah, so the employee are not allowed to impose a condition in the contract of service that offer to you, meaning to say that you have to sign the contract of service before you join the organization, which stated in that contract of service, on contract of service or the contract of employment, saying that you are not allowed to join or to continue to become a member of trade union in that organization. So the employer cannot do that. Number 2, the employee also not allowed to do this intimidating behavior, which is B, refusing to employ a person because he is not a member or an officer of the trade union. So this is also not permissible by law. The next intimidating behavior by the employer is to discriminate against a person as regards to employment or promotion or any condition of employment or working conditions because he is not a member or an officer of trade union. Meaning to say that if you are a member of the trade union or you are not member of the trade union, so the employer cannot actually refuse, for example, or discriminate the employees in terms of their employment. For example, refuse to promote the employees or affect in terms of their performance or something like that. Yeah, so this is another examples of the intimidating behavior. The next one, D, the employee also not allowed, okay, to dismiss an employee or injuring him in his employment or altering his position to his prejudice because the employee wishes to become a member or an officer of a trade union, or because he participates in the promotion or formation of the activities of a trade union. So if you become an employer someday, perhaps, yeah, so if any of your employees in your organization, okay, join the trade union, okay, or wishes to become a member of trade union or become an officer of the trade union or participate in the activities of the trade union, so you cannot dismiss them or injure him in the sense or because of they join the trade union. The fifth intimidating behavior, if any person in your organization become a member of the trade union or become a trade union officer, okay, so you are not allowed to induce them, yeah, or to stop them from being a member or officer of the trade union. And how you can do that? By offering any forms of advantages on or for any person, or by offering to do so to this person. So you are not allowed to do this. So this is all considered also part of the intimidating behavior, which is part of the Employer Prohibited Act. The previous slides we have learned about Employees Prohibited Acts, and we have also learned about the intimidating behavior. However, Section 5 and Section 2 Industrial Relations Act, which acts as a provision to Section 5 and Section 1, it clarifies that for certain situation or condition, employee is not prohibited from the first one, refusing to employ a person or promote a workman for proper cause. It must be for a proper cause, remember. And number two, employee is not prohibited from transferring, laying off, suspending or discharge a workman for proper cause. Or number three, employee also not prohibited from restraining a workman occupying a managerial position from being or becoming a member or an officer of a trade union catering for workmen not occupying managerial positions. Or the employer also not prohibited from restraining a workman employed in the confidential capacity in matters relating to staff relations from being or becoming a member or an officer of a trade union. So this slide actually explained about what are the things that the employer can do. The employer can do for a certain situation. For example, like they can refuse to employ a person, they can refuse to promote a workman just for a proper cause. It must be a proper cause, a valid reason. And the employee also not prohibited and not wrong to do this, transferring, laying off, suspending, discharge workmen for a proper cause, for a valid reason, something like that. And restraining workmen occupying manager position from being or becoming a member or officer of trade union, okay, which also concerned about the catering for women not occupying manager position. And at the same time, for employees who are actually employed in the confidential capacity, then the employee is not prohibited from restraining them to become a trade union member or officer. Remember from previous slide, I had mentioned about proper cause. So what does it mean by proper cause? According to Employment Act, employee has the right to dismiss workers if that workers absent from work for a long period of time. So this is just one of the examples. Nevertheless, according to Section 5, subsection 2A, employer can refuse to employ a person if workers due proper cause, such as transfer from company A to company B. Number two, Section 5, subsection 2B, requiring that employees upon his appointment or promotion to a managerial position shall stop to be or not to become a member or an officer of a trade union. Meaning to say that if you become a member of trade union, employees trade union for example, and then suddenly you are promoted to hold a managerial position in that organization, meaning to say that you are no longer categorized as employees. So you are no longer part of the employees union. So the employer has the right to stop you to become a member or an officer of the trade union. The next one, Section 5, subsection 2C, requiring that any employees employed in confidential capacity in matters relating to staff relations. You can underline the word confidential capacity, relating to staff relations. So if you hold this position, you may be stopped to be or not to become a member or an officer of a trade union. So the employee has the right to stop the employees who are member or an officer of trade union when you actually appointed or hold a position that holding a confidential capacity related to staff relation. Why they do this? Because those who are holding this position, confidential capacity in matter to retain staff, so you might hold what we call you have the power to access the information on the staff relations, staff information. So it might involve in a lots of confidential capacities. You are no longer you what we call entitled to be a member of the trade union or the officer of the trade union. Section 6 Industrial Relations Act 1967 also requires employers to grant all written application for leave or absence made by employees who are officers of trade union, whose intention is to carry out his duties or to exercise their rights as such officers if the purpose and duration are specified and the duration is reasonable. This slide explains about the employer should actually provide or grant or allow the officers of the trade union, or the employees who are the officers of the trade union, if they apply leave or absence from work, okay, to exercise their duties and their rights in the trade union. For example, to involve in the trade union activities, lawful activities under trade union. For example, like to do the collective bargaining, to do the research representing the trade union in meeting, for example. But if you want to do that, the trade union members or trade union officers want to do that, you must actually write a letter or write an application to the employers, yeah, and it must be specified clearly, and the duration must be reasonable, so the employer has to grant what we call permission for these employees or officers of the trade union to do that. The previous slides we have discussed about the Employees Prohibited Act. We have learned about the do's and the don'ts of the employers in the case of employees form trade union, join the trade union, and participate in the programs or activities of the trade union. This slide we will explain about the offences of the employers, especially in the case of employer who dismiss an employee, injured or threatened to injure him in his employment, I mean employees in their employment, or altered or treated to alter the employee's position due to the prejudice of the employers. And this can also be considered as the discrimination. We have 7 situations whereby we can consider as an offense if the employer take an action, for example, like dismiss, injured, threaten, or to injure the employees in terms of their employment, or alter their position, treated to alter the position. Okay, so what are the situations? So the first one, if the employee is or proposed to become an officer or member of a trade union or of an association that has applied to be registered as a trade union. So for example, like in the situation of your employees propose to become a member or the officer of the trade union. Okay, so the first situation. Second situation, there must be a situation whereby in your organization, if you have the trade union, when the employee is entitled to benefits of a collective agreement or an award of the industrial court. You have to understand one thing. Collective bargaining is a very important process or activities in the trade union. Meaning to say that when we do the collective bargaining, it is actually the bargaining process between the employees and employees, especially in regards to the salary, the fringe and benefits, and many more. So if the employees gain the benefits, entitled to get the benefits of that collective bargaining, yeah. So this is the second situation. So the third situation, if your employees who involved in the trade union, for example, has appeared or proposed to appear as a witness, because there are certain situation of disagreement, or what you call situation whereby when we bring case, or the trade union bring the case to the industrial court, then the employee become the witness. So the employee has given or proposed to give any evidence in the proceeding under the act, yeah. And the fourth situation, if the employee is being a member of the trade union which is seeking to improve working conditions, and it is dissatisfied with such working conditions, so the employee propose the idea and recommend few things through the trade union to the employers. So if your employees did this 4 situation, then the employer cannot actually dismiss the employees, or injure or threaten to injure him in their employment, or to alter or threaten to alter their position because of this situation, yeah. So when you do this, when the employer do this, this is actually considered as commit an offense. To continue with the previous slide, an employee, if they become a member of a trade union, and if they actually involve in the collective bargaining or any meeting related to their roles and to give their input and opinion in collective bargaining, which is to bargain the rights and the welfare of their employees, okay, which is stipulated under section 13. Also involved in the negotiation under this act, or in the case of the trade dispute which has been reported to the minister in accordance with the part 5 and part 7, then the employer cannot actually dismiss the employee, injured or threaten to injure the employees in their employment, or to alter or treat them to alter their position due to the prejudice. Okay, and number 6 actually, yeah, so if the employee has absent himself from work without leave for the purpose of carrying out his duties or exercising his right as an officer of a trade union, okay. In this case, it explains about, if the employee who become a member of the trade union or the officer of the trade union, but they absent from work, okay, and even though he absent from work without leave, yeah, but the reason why they absent from work because of they carrying out their duties or exercising his right as an officer of a trade union, okay, then the employer again is make an offence if they actually dismiss the employee, injured or threaten to injure the employee in their employment, or to alter or treated to alter their position, okay, but with the what we call condition that he already applied for leave in accordance with section 6 before he absent himself, and leave was unreasonably deferred or withheld, meaning to say that they already apply for leave, to exercise his duty in as an officer of the trade union, but the employer refused to accept their application of leave. Yeah, so that is actually what is actually explained in this part. Okay, the next one in number 7, when the employee is being a member of a panel appointed under section 21, whereby has absented himself from work for the purpose of performing his functions and duties as a member of the industrial court, and has notified the employee before he absented himself, meaning to say that if the employee become a member of the trade union and being a member of the panel appointed under section 21, and before become a member of this panel appointed, for this case, this employee already notified the employer, means to say they already asked for permission from the employer to to become a member, to become a panel, and then he definitely need to absent himself from the purpose of performing his function, and then again the employer cannot actually dismiss the employee. So the employer actually make an offense, if they dismiss the employee, injured or threatened to injure him in his employment, or altered or threatened to alter his position due to his prejudice in these cases or in these situations. Furthermore, Section 6 Industrial Relations Act requires employers to grant all written application for leave or absence made by workmen who are officers of trade union and who intend to the leave applied to carry on their duties or to exercise their rights as such officers. Okay, meaning to say here that the employer must what we call permit or allow or grant all written application. It must be in written application, for leave or absence made by workmen who are, if the employees actually are the members of the trade union or the office of the trade union, intend to apply for leave, because they want to carry out their duties and to exercise their duties, their right as an officer of the trade union, but provided that the first one is the application specifies the duration of and the purpose for which the leave is applied for. It means that, so in that application, the trade union officers or the employees who are member of the trade union would like to exercise their duties or their rights in the trade union, so they must mention specifically in the application, in terms of the duration, how many days, for example, they want to apply for leave, and what are the purpose, for example, representing what we call the trade union in collective bargaining, for example, in the meeting or attending the seminar, or many more. Okay, and the second one, the duration specified is no longer than what is reasonably required for the specified purposes. And number two, you must also make sure that, I mean, the employees of the employee who become a member of the trade union or the officer of the trade union must make sure that the duration of the leave that they applied for, okay, is actually not longer than what is reasonably required for the specific purpose. Yeah. However, a workman and officer is not entitled to leave with pay for the duration of his absence if the purpose for which he was absent has nothing to do with his employer. For example, yes, you can apply for leave, okay, but then you can get what we call payment, or leave with payment, with salary, but for the with related, that must be related to your employment and with your employer. But if you are representing the trade union, which has nothing to do with your organization, and then you are not entitled to get the what we call leave with pay. Finally, Section 20 Industrial Relations Act restricts employers from arbitrarily dismissing workmen lacking the protection afforded by union membership. It means that the employer are not allowed to dismiss or to terminate their employees if the employee is actually have or called inadequate or lack of protection provided by the union membership in their organization. So if the employee already dismissed the employee, but this section also enable the workman or the employee to make representations in writing to the Director General of Industrial Relations to be reinstated in his former employment. Meaning to say that the what we call employee can write, and can apply to the Director General of Industrial Relations, and to make sure that the employer need to reinstate it or to re-employ what we call this employee, because this is what is considered as what we call discrimination. So the workman or the employee is protected under this act. So previously we have seen what we call the Employees Prohibited Acts, but now in this slide we will explain about the Employees Prohibited Acts. So Section 7 Industrial Relations Act 1967 prohibits employees and their trade union from the following actions or situation. The first one, the employee are not allowed to persuade employees to join or not to join a trade union without employer's consent. You can underline the word without employer's consent at his place or business and during working hours. So whatever it is, you must get the employer's consent first before you actually what we call actively involved in the trade union activities. But this prohibition does not apply if the persuading was done by an employee employed in the same level and in any way which does not affect his normal duties. Number two, the employee also not allowed or prohibited to be intimidating or threatening a person to become or not to become or continue to be or stop being a member or an officer of a trade union. So you cannot intimidate them, your colleague, for example, your co-workers, or you cannot threaten them to become or not to become or to continue to be or to stop being a member of an officer of the trade union. Number three, inducing a person not to become or to stop being a member of an officer of a trade union by confer or procuring any advantage on or for any reasons or even offering to do so. So like now for number two, you cannot intimidate or threaten a person to become, but for the number three is you also cannot what we call induce a person not to become, we need to stop them to being a member of the trade union. Based on employers and employee prohibited actions, we can summarize their act as intimidating behavior if the acts done by the first one uses violence to some other person among the employees or employers, persistently follows some other persons and hides any tools or property of some other persons and watches houses or place of residence of some other persons. Last but not least, we will talk about the powers of the Director General of Industrial Relations, DGIR. So basically there are three major or main powers of the Director General of Industrial Relations. The first one is the DGIR actually has the power to provide or to give a recognition of trade unions. Yeah, meaning to say that he can actually recognize the establishment of the trade union or the existence of the trade union of that particular organization, of certain organization. Number two, the Director General of Industrial Relations also has the power to or provide the notice of strike and lockout. For example, if the trade union apply to the DGIR to organize the strike or lockout, okay, in the case of the industrial dispute in the organization, so the DGIR can allow them, okay, can provide a notice to organize the strike and lockout to this what we call industrial relations. And the third one, the Director General of Industrial Relations can actually play a role or have the power to representation on dismissal in the case of if the employees or officers who become members of the trade union or officer of the trade union, then they are dismissed due to their involvement in the trade union, then the Director General of Industrial Relations can play the role, in the case of in representation, okay, to secure or to provide protection and welfare for the employees, okay, in the case of dismissals. I think that's all for chapter 4. So if you have any question, please ask. Thank you.